Hello all. So 2025 marks the completion of 50 years of national emergency, where in 1975 government led by Ms. Indira Gandhi recommended to the President of India to impose Article 352 or national emergency in the country. When emergency was in place, so many of the fundamental rights of the citizens were taken away, including Article 21, which gives citizens right to life and personal freedom. And hence, in this context, one very important case which was reached to Supreme Court in the year 1976, which is called as ADM Jabalpur versus Shivkant Shukla case, or informally famous as habeas corpus case, is very relevant from all competitive exam point of view. So we'll be discussing about this case in this video. To begin with, let's try to understand the background of this case. So during 1970s, few such incidents or events have happened which led the government or the Prime Minister to recommend the President to impose national emergency. What events? So at that time, in various states like Gujarat, Bihar, the student community was not very happy or discontent with the government. The government in those states used to be of Congress party, and hence in Bihar, the student community approached to one of the freedom fighter, that is J.P. Narayan, and hence J.P. movement started at that time in India. J.P. Narayan, he gave the call of total revolution, meaning Sampurna Kranti in India. In fact, in 1975, he asked the President or he asked the Prime Minister to resign on her own or voluntarily. In fact, at the same time, in 1975 only, one another development which had happened is that the Allahabad High Court in Raj Narayan Shukla case ordered or basically disqualified the Prime Minister Ms. Indira Gandhi from Lok Sabha. All these developments led the government or Ms. Indira Gandhi, the Prime Minister, to recommend to the President for imposition of national emergency. During the time of national emergency, the government used or misused one particular act or one very draconian act which was passed in 1971, is called as MISA. Full form is Maintenance of Internal Security Act. This act gave the government the power of preventive detention, meaning a person can be arrested even without committing a crime. Preventive. So to prevent a crime from being committed, a detention of a person can be done, right? So this act was misused during the time of emergency. If you all know, more than 1 lakh Indian citizens were jailed without trial. Even the very important, very popular opposition leaders also, all of them were behind the bar during those 21 months of period of emergency. In such a case, a case was reached to Supreme Court saying that this misuse of this act, MISA Act, right, it violates the fundamental rights of Indian citizens, especially Article 21, right to life and personal liberty. I'll read out the Article 21 for you people. It says, no person shall be deprived of his life or personal liberty. So state cannot take life of any person or personal liberty, meaning state cannot arrest anybody except according to procedure established by law. If Parliament has given a law Parliament has given a procedure by which only a person can be either arrested or his or her life can be taken. Otherwise, state has no power to take away a person's life or personal liberty. That's what Article 21 says. But during emergency, as we have seen, that personal liberty of many people, lakhs of people was taken away. They were arrested illegally and without any trial. And hence people, they approached to Supreme Court saying that Article 21 is being violated. Before we understand the judgment given by Supreme Court in this case, let's try to understand what do Article 358 and 359 of the Indian Constitution say. So we have discussed that Article 352 is about national emergency, right? Article 358 says that when emergency will be in place, Article 19 of Indian Constitution, which apart from other rights gives right of or freedom of speech and expression, Article 19 will automatically be suspended. So that's what Article 358 says, that in the case when emergency is in place, Article 19 will automatically be get suspended. Article 359 says that apart from Article 19, any other fundamental right can also be suspended by President. So the difference between two is Article 19 gets automatically suspended, but for any other fundamental right to be suspended, President has to pass an order. That's what Article 358 and 359 of Indian Constitution they say. Now coming to this case, when this case was filed in Supreme Court formed a 5-judge bench headed by the Chief Justice of India at that time, Justice A.N. Ray, right? Same Justice A.N. Ray who was made CJI Chief Justice in 1973 by Indira Gandhi government, even though he was not the senior most in Supreme Court, because in Keshwanand Bharti case he ruled in favor of government, right? So Justice A.N. Ray, he formed a 5-judge bench to listen to this case. This 5-judge bench with a majority of 4:1 passed the verdict saying that Article 358 and 359 they empower the government to take away or to abridge the fundamental rights during the time of emergency, and hence if Article 21 is violated, there is nothing wrong with this, right? So 4 of the judges including the Chief Justice of India was in favor of the government, saying Article 21 during the time of emergency can be abridged, can be taken away. The only dissenting judge in this particular case was Justice H.R. Khanna. Justice H.R. Khanna, if you all know, he was uncle of the recently retired CJI Justice Sanjeev Khanna. Justice H.R. Khanna was a lone dissenting judge. He said even during the time of emergency or under any circumstance, right to life and personal liberty cannot be taken away. In fact, during the proceeding, he asked to the Attorney General, can during the time of emergency a police person can kill an innocent civilian, and that innocent civilian or his family members, don't they have any right to approach to judiciary, right? So can civilians be killed during the time of emergency and no case be filed because Article 21 is not in place? So he has said that Article 21 or right to life or liberty, it is not just a constitutional right, it is a natural right also, and hence to be given to citizens at all times, right? Not just in normal circumstances, even during the emergency time also people should have Article 21 right to life and liberty. So Justice H.R. Khanna, he was the dissenting judge, but because 4 of the judges were in favor of taking or abridging the Article 21 during the time of emergency, the judgment was passed in favor of government. When in 1977 emergency was removed, a new election was done or conducted. In this election, if you all know, Congress government or Congress party, it lost the election, and Indira Gandhi herself lost the election. There was a new government formed, government of Morarji Desai of Janata Party, right? So for the first time in India, a non-Congress government formed in center, Janata Party's government. Janata Party government in 1978 passed 44th Constitutional Amendment Act. By this Amendment Act, the judgment given by Supreme Court in habeas corpus case, it was overturned. The Parliament had amended the Constitution saying that even during emergency, Article 20 and 21 cannot be taken away. So Article 20 and 21 are they will be they are sacrosanct, they cannot be taken even during the time of emergency. That's what 44th Amendment Act has done. So I hope this judgment is clear to you, that in 1976 when habeas corpus case was, that was the verdict was announced, the verdict was in favor of the government. But in 1978 by 44th Amendment Act, Parliament has said that Article 20 and 21, right, they cannot be taken by government at any cost. You see, the judge, the only dissenting judge, Justice H.R. Khanna, right, he was punished for this judgment also. In 1977, when Justice A.N. Ray retired, he was the senior most judge in the Supreme Court and hence was expected to become the next Chief Justice of India. But he was ignored by Indira Gandhi government. In place of him, Justice H.M. Beg was made the Supreme Court Chief Justice, even though he was not the senior most, he was junior to Justice H.R. Khanna. Right? All these interference by executive into the functioning of judiciary later on became the reason for evolution of collegium system as well. That also we have discussed in another video. So Justice H.R. Khanna, because even though he was senior, he was ignored, he resigned immediately, right? So this is what the case of habeas corpus of 1976 is. I hope through this video you have understood what is Article 21, how it is protected even during the time of emergency. So if you have liked this video, please do subscribe our channel. Thank you so much.